Hi, everyone. You're welcome to Lawyers Infohub. It's a pleasure to have you all on this platform. Um, so today we are having a wonderful session. We're looking at the understanding the dynamics of law practice, and it's a pleasure and a great honor to have a learned senior advocate of Nigeria in our midst as our guest. So, friends, today I'm having Mr. Afam Osigwe, a learned senior advocate of Nigeria, who is a senior partner of Law Forts, a thriving commercial law firm in Nigeria. He was the former MBA secretary and has served in various capacities and has left indelible marks in the law practice and in the law profession in Nigeria. You are welcome, sir. We are most grateful to have you.
Thank you so very much.
Yes, sir. Thank you,
I'm
sir.
sorry for that mix-up about connecting to the program.
Okay, no problem, sir. We are very grateful. Thank you for your time.
I'm trying to relocate too so that we can.
Okay, sir.
But I'll go ahead.
Okay, sir. Thank you for coming. We've done the introduction. So, sir, you have climbed through the cadres of law practice and you have served in diverse capacities. You've done so, you've been in various capacities, served in various capacities, and over time, you are now a senior advocate. Can you please tell us what has kept you going? Yeah. Sorry for that.
That's okay.
Okay.
I never hesitate to say that the grace of God
Okay.
has kept me. The grace of God has
Okay.
kept me going.
Okay,
And
sir.
then I've always had an idea of what I wanted. I've always tried to
Okay.
be focused. And I've
Okay,
also
sir.
had supportive friends,
Okay.
colleagues, and family who have in diverse ways supported me and then contributed to the little successes I have recorded so far in life.
Okay, sir.
And I've also believed in challenging myself, in improving myself, and never resting on my oars. So,
Wonderful.
in a nutshell, part of the reason some of the reasons that have contributed to, like I said, the few successes I've recorded in life.
Thank you very much. Sir, do you think young lawyers of these days they have all they need to thrive in practice? The young lawyers, do you think they have all it takes, all they need to thrive in law practice?
Well, there will never be a yes or a no answer to that question. Because what may be sufficient for Mr. A may not be sufficient for another person.
Okay, sir.
And we will never have equal opportunities.
Okay.
But the important thing is for us to have sound legal education
Okay.
and then also have an idea what we want to make of ourselves and what we want to put our degrees or qualifications to.
Okay,
Now,
sir.
some person may come out of school and get employed immediately. Some may get that job even before they come out. Some may never get employed at any point in their lives. So we come out of law school, not get a job, and get a lucky break in that they get clients or even a client who would have the confidence in them and give them jobs to do. So there's no hard and fast rule. So, but generally, the poor economic situation makes it difficult for majority of lawyers to thrive in the profession. The point needs to be noted that in the last 5 years or thereabout, a minimum of about 6,000 persons on the average join the legal profession in Nigeria.
Yeah.
And a very small percentage of this number ever gets any form of employment in a structured environment. So we depend on their ability to do their hustle, to get involved in things other than law to survive. So we depend on their ability to do networking, marketing, use of the internet in legitimate ways I'm talking about to also
Yeah.
survive. So it's very difficult. And I mean, it will be very difficult for just lawyers, for me to think that all lawyers will thrive in an economy that has double-digit inflation, where the government borrows to pay salaries and also to service debts, and where the naira keeps being devalued with insecurity and a number
Yeah.
of other societal maladies, for lawyers to be an exception. So lawyers are hit as much as other professionals and also non-professionals. That's why I
Okay.
said your question cannot take a yes and no answer. But we must be able to answer that question bearing in mind that people are differently able and opportunities do not present themselves in the same way. And some people, even when they get the opportunities, may not recognize that these are opportunities. So
Okay.
also our ability to perceive opportunities as opportunities also has a role to play. And some people may also be laid back, oh, well, the economy is bad. What do you want me to do? I don't have a job. Where do you want me to go in the morning? At least let me stay in my parents' house and eat. So attitude also comes in. And
Yes.
I can go on and on and on and on.
I need to say that. Yeah. So, over the years, there has been a decline in pupillage. Many young lawyers don't like to undergo pupillage. What do you think is the cause of this problem, and how can it be remedied?
I think there's a wrong assumption. There has not been a decline in pupillage. There hasn't been sufficient opportunities for pupillage.
Okay.
I mean, there's no week I don't get a request from a young lawyer looking for a place to work. And it
Okay.
pains me that I do not have opportunities or space for all of them. And I would like to imagine it is the same thing every other person faces. There are not many law firms capable of employing tens or hundreds of young lawyers to work in the firms. And if you don't have the spaces, it will be wrong to pretend that it is because of their unwillingness to do pupillage. They
Okay.
have to, we need to have spaces for them to do pupillage before we blame them for not taking them up. It has never been the case that law firms can't get lawyers who want to do pupillage. It has always been the case that law firms can't employ the people who seek to do pupillage there. So it
Yeah.
still takes us back to the unemployment rate. I think the
Mm.
National Bureau of Statistics put unemployment rate at about 3.4% for
Yeah.
last year, and is expected to get to 34%. And youth unemployment is at about, I think, 47%. I'm not sure, but it's high. So if you factor this in, and if that is a national
Yeah.
statistics, and lawyers are also included in these statistics, so it shows that the economy is not growing fast enough for there to be space to employ so many people. So if we are to remedy it, then law firms should get stronger. They should go into partnerships, have synergy, grow law firms from sole proprietorship to something that can take in many more lawyers.
Yes.
So until we have more spaces that we are looking for lawyers and the lawyers are refusing to take up the spaces, then we can't say that young lawyers
Yeah.
don't want to do pupillage.
Mm. Thank you very much, sir. Sir, over the past few years, since 2020, COVID came and changed a lot of dynamics in terms of the way practice is now being done. Technology is the order of the day. So, what measures do you think the judiciary can put in to utilizing technology for ease of justice delivery?
So I think that the lesson many countries have learned from COVID, that you can use it to cut time wasted in court. For example, a court fixing a matter, maybe fixing 14 matters for hearing and having all kinds of sitting in court waiting for their turn. So that the
Yeah.
courts are failing to utilize scheduling. So if you have
Okay.
14 cases, you say, okay,
Yeah.
you, Mr. A, you come by 9, you come by 9:45, you come by 10:30, you come by. So you don't need to sit down all day waiting to be heard. So the
Okay.
courts have not utilized that, which is one of the things COVID has taught us, that you don't need to always gather a large number of people in the same place
Oh,
because of
yeah.
possibility of spreading any communicable disease faster.
Yeah. Yeah.
Relying on technology. Now, court judge must come in robed, they must all come in robed, you have to do court trials, you have to. So the courts are refusing to embrace technology as much as possible. Some of these hearings do not need to take place in person in courts.
Okay.
So the Supreme
Hmm.
Court has also shown that judgments delivered virtually do not violate the Constitution. So why
Yeah.
are the courts very unwilling to take up this way of doing business, so that even the judge can be in faraway America and conduct hearings here? Many courts have invested money in putting up e-filing, but it's only in name. A lot of money spent, and yes, the court
Yeah.
lack facilities for
Hmm.
for the filings to be done. There's an
Yeah.
argument ongoing and no legislative effort is being made to correct that. That because of filing an affidavit that the law says you must swear to an oath before a commissioner for oaths. What step are we taking to amend the Evidence Act or to give a purposive interpretation to say that if, as I'm speaking, having this interview with you, which is a virtual face-to-face, that if I do that in deposing to an interview, into an affidavit, and the commissioner for oath is at the other end, and I fix my signature, and then he signs digitally, that it meets the requirement of the law. And we keep doing things that waste our time. The courts have refused to. I was at a court just some time ago, and the judges were lamenting that they don't even have access to internet. They can't do research online. And we're talking about the 21st century. What would it cost? And yet they'll buy diesel, they'll buy DSTV, pay for DSTV the subscription for their homes. What will it take to get Wi-Fi or a fiber optic cable so that they'll have enough bandwidth to conduct hearings, take it to their homes, and make life easier for them? So we have failed to learn from the lessons of COVID, which has emphasized on use of technology to limit what people do. Now, in many parts of the world, especially in the Western world, people choose to work from home. And many organizations report that productivity is up with people who work from home. And they still get paid and they still get all the job done. How about we taking away these lessons and implementing them in our own local circumstances? Oh, well. Sometimes I just wish I don't have to talk about these things.
It is all well. We hope that the right things will be done. I would say that remuneration has always been a drawback for young lawyers to work in law firms and other organizations. What do you think we should do to change the narrative? Issues of remuneration.
It's tough. Now, for example, government can only fix a minimum wage. And government has fixed a minimum wage, and some law firms argue that as long as they meet the minimum wage, they are not in violation of the law. But on the flip side is the fact that for a law firm to get good services from juniors, you have to pay well. As Taribo West was reported to have said years ago, he said if you pay peanuts, you get monkeys. So sometimes it has to be an issue of negotiation between the law firms and the lawyers they employ. And I can say to you, some law firms can pay much better than others. Some of the better organized law firms, the partnerships are able to pay better. And they also have a structure to allow a counsel to grow from being an associate to a senior associate to a partner. So you can own the firm. So for me, the best way to answer this question is to say, first of all, we have to figure out the way to ensure that law firms earn better. So if you look at, I think, I'm not sure now, Section 14, I think, of the Legal Practitioners Act, which sets up a committee called the Remuneration Committee, headed by the Attorney General of the Federation, and which has other Attorney General of State as members, and an NBA President and 3 other members. He said this committee shall have the power to fix minimum fees or charges payable for legal services. So how about we getting this committee to sit and fix an amount that lawyers should not charge below? Now, if you're able to make this and make a subsidiary legislation, lawyers will be strengthened the ability to negotiate with clients and say, no, this is what the law says. I can't go below this. And also, we step up the enforcement procedure that ensures that lawyers who violate these regulations are taken before the disciplinary committee. That is stage one. Now, it also would help the majority of lawyers who cannot get employment to be able to charge better, rather than blaming them for saying at all, I ain't bad. Even if I 1K, make I get at least I will free it. Now, when you do this, you move to the next phase of encouraging lawyers to form partnerships, to specialize in different areas, to really find their strength. Then emphasize on the continued professional development. Then the MBA will drive it and try to provide some of it free to the young lawyers to help them really understand what practice is all about, and also steer some in some direction they may not have thought about.
Of course.
And when you greatly professionalize the what we do and put in place laws that enable lawyers to start better and create an environment of trust and regulation that will make it more profitable for us practitioners to team together to practice law.
Okay.
Then we will be doing well. And another aspect of it that I like to talk about, there is very little entrepreneurial content in legal education in Nigeria. People are trained to look for jobs. People are not trained to be persons who can be creative, who can use their mind. So it's all about you getting job in CBN, NNPC, LA company, this. We are not trained to think independently that even if these jobs don't come, as I've shown, they don't always come. To be able to find something to do with dignity. And we'll have some kind of, in some cases, some dim view of what legal practice is all about. Sometimes those who go to court look down on those who don't go to court as if they don't know law, they don't practice law.
Yeah.
And I always hold the view that we all mustn't go to court. Whatever you choose to do, do it. Some of the finest lawyers in Nigeria, very wealthy, so I know, don't practice law in the sense of going to court. Yet they practice law. Mr. Gwengo, they runs one of the best law firms in Nigeria. He doesn't go to court. And nobody has suggested he's less a lawyer than others. Mr. Olida, just to mention the few I know, Mr. George told me.
Yes.
We mustn't all go to court. Indeed, the court will never be enough for all of us. So for us to realize that we have limitless opportunities. A lawyer, by virtue of his training and learning, can work in different areas. For us not to limit ourselves, and for us not to give up when the jobs are not there, to simply sit down waiting for it to come, to keep on putting in CVs. So that's why I also looked at the legal education side of it, the lack of entrepreneurial content in our teaching.
Thank you very much. I'm very grateful for that. I just hope the law school can be reviewed in that light. So the role of networking in legal practice cannot be overemphasized. What advice do you have for young lawyers, even older lawyers, in terms of how to network to grow their practice?
If you try to, that street aphorism, chop alone, die alone.
Yeah.
It also applies here, because if you stay alone, you may become jaded without knowing it. You may not know, you may think that what you consider knowledge may actually not be the real knowledge. Networking with others helps strengthen you. Like the Bible says, iron sharpeneth iron.
Iron, yeah.
Meeting with others, associating with them, even doing some work with them will make you a better lawyer. There are some even briefs that you do with other law firms, because that you may be able to charge more and you'll be able to deliver better services and more timely services. So sometimes you may think that if you work alone, you charge alone, the whole money is yours. No, never. So as I get older, I see the importance of networking, working with others, being able to share fees, share work, and so it is the way to go. Even liaising with law firms, even in Lagos, across cross-border networking helps. Many law firms in Nigeria sponsor their lawyers to international conferences to network.
Yes.
So that if those who have anything here, they can assist them, can help them with it, and vice versa. And it works for them.
Yes, it does.
It may look like a stupid thing to those who don't pride it. But those who do know that the return on the investment of paying for this conference and sending people to them is unimaginable.
Of course.
So it is the way to go. You must go beyond your known space. You must try to reach out to others, have a handshake with them.
Yeah.
Because at the end of the day, there's more to smile about in them than in not doing them.
Thank you very much. I do hope that people who will watch this content will stretch out their hands of networking and reach out. So you became a senior advocate at quite a young age, and for lawyers,
I wouldn't say
young
that
lawyers,
if you ask me.
yeah, but not too old. You got it.
I will accept that part of it.
Yeah, not too old. So for young lawyers and other lawyers who desire to become senior advocates, what do you have to say to them?
It's always a difficult question to answer, because being a senior advocate is very important, is very good for those who have chosen the path of being courtroom lawyers, who do litigation.
Yeah.
But Why I say it's difficult is, see, sometimes we place so much premium on it as to suggest that those who don't have it may be lesser lawyers or may not be good lawyers.
Yeah.
And that impression should not be created. There are many fine lawyers who have taken the decision that they don't care about it, they are never going to apply for it.
All right.
And they're excellent lawyers. What if perchance any of you listening to me or who will listen to me wants to take sale? Find out what the requirements for it are.
Okay.
Work on getting them. Ensure that you guard your reputation jealously. Make sure that you're a legal practitioner with integrity. Deliver quality services to your clients. Do pro bono services to those who may not be able to afford legal services, because there is
Yeah.
a pro bono content of it. Ensure that the cases you do, which you use for the application, are cases which have added some value, which have decided some new
Yeah.
things,
To the
which
legal.
to the legal, yes, to the legal
Yeah.
profession and to
Yeah.
case laws.
Yeah.
So be that, and in doing that, don't worry about other people who are also planning to take it. You're not in competition with them.
Yeah.
Focus on what you want to achieve and do it. And if for any reason you don't get it at the first trial, keep trying until you get it. The important thing is not in failing, but in rising each time we fail. So if
Okay.
you want to do it, and also it will be also good to interact with those who have taken the sale, get the
Yeah.
advice. There are a whole lot of things you can learn from them about how to do the application, how to arrange your documents and other things, how to start preparing. Because some of the requirements like paying annual practice fee consistently by month of first for at least 10 years prior to the application instruct that
Application.
if you miss one of the years, you start
Yeah.
afresh. So these are very important.
Very important. So the earlier you start, the better. Thank you for this
The better
advice.
for you. It's
Yeah.
not something you wake up and start preparing.
Overnight. Yeah.
No, there's no
Yeah.
overnight in it.
Yeah. Yeah. So you've been a consummate barman who have served in various capacities in the FBA. And it's worrisome that some lawyers do not partake in MBA and do not also allow lawyers working for them to partake. So what do you have to say to this set of lawyers and for the lawyers too who are working under these lawyers that do not allow them partake in MBA activities?
Well, I can only advise them to allow those who are willing to be part of the MBA to be involved.
Okay.
Some law firms actually discourage that because it can also be time consuming. And I would like to imagine that if you work for a
Yeah.
firm and then you get elected into an office either at the national level or a
Yeah.
local level, your ability to give full attention to the firm that pays you or the organization that pays you will be somewhat affected. So you also
Yeah.
need the buy-in of your firm to know that when you start participating, there will be quite a long period of absence, which would affect your ability to deliver on services. So it's to work out that arrangement. That explains why some also have strong aversion to the even from merely allowing their lawyers to attend meetings, which happens maybe once a month. So that's
Yeah.
also a challenge. And I would only ask that allow these lawyers to mix with their colleagues, be part of their professional association, and be able to contribute their quota towards national development by serving at the bar.
Yeah.
But you said I'm a consummate barman. I
Yeah.
sometimes prefer that, which people would see me more as a consummate legal practitioner than as a
Okay.
barman, because sometimes, I mean, I'm not blaming you, like just a wish.
Okay.
I'm used to that.
Yeah. Okay.
You come across feeling that people think of you as just somebody who only plays NBA politics and nothing else. Maybe
No,
you
no,
don't have a good
no.
practice, or you're not serious
Yeah.
with your practice. You have so much
Yeah.
on your hands that you just need to say NBA and you're over there.
Yeah. Yeah. Thank you very much, sir. Sir, over time and over the years, a lot of lawyers they have been struck off the role for one issue or the other. So, what advice do you have for young lawyers with respect to the need for them to carry out their practice within the
Hello, frozen.
yeah?
Sorry, I didn't hear you. It was frozen a while ago.
Okay, so I
But I
was
think
saying
you are
that over
talking
the
about what
years,
advice do I have
for
for
young
young
lawyers
lawyers?
to respect to them practicing within the ambit of the law, in the wake of certain lawyers' names being struck off the road over the years.
Okay, let me just note that
Yeah.
both young, mid-level, senior lawyers, senior advocates
Yeah.
are usually subject to disciplinary action. It's not something that is restricted to young lawyers.
Yeah.
Because these are ethical issues or issues of professional misconduct.
No.
Sometimes people cross these lines and they have to be up for discipline. So it's for every person.
Yeah.
And people also have petitions written against them, which are also dismissed. Well, in the sense of facing a trial, they have faced it, and so they fall within your quiz. So sometimes you can be careful and still have a petition written against it by a client who feels disappointed that some one thing or the other didn't go as planned.
Fine.
What it is, yes, and then you may also, how do they say it? Get your name struck on the roll, and then such striking off may be upheld by the Supreme Court or suspended or censured. Or I will only say that lawyer general should remember that the rules of professional conduct are there to guide them and their activities in their relationship with clients and the society and their colleagues and the courts even. And so that if they do their best to ensure that they don't run foul of these rules or any law of the land, that they will be fine.
Okay. Yeah. Thank you very much, sir. So I believe in mentorship. I believe in the older lawyers mentoring the younger lawyers, because if we don't mentor the new generation, we may not have what we expect. So what do you think MBA should do? What efforts do you think MBA should put in towards ensuring effective mentoring of young lawyers?
Well, at the level of the body of benchers, an effort has gone
Yeah.
up to set up a mentoring committee, which is to work out some guidelines for mentorship. And the whole idea is to mentor lawyers from university, have people you take under your wing. Even in the Bible, Paul talked about learning at the feet of Gamaliel, who was his teacher. That's some kind of mentorship where you look up to the person and watch them. Some can call it some kind of not an apprenticeship thing, but somebody you look up to, who you go to for guidance, and all that. I may not be able to give you a full answer how MBA can achieve that, considering that MBA does not have full institutional framework at the moment to achieve that. Well, just to say that we can take a starting point from branches where young lawyers can be grouped and placed under the care of some senior lawyers who will guide them. You don't have to work with them, because you also see mentorship as also meaning that by being their mentor, you have to also take care of their financial problems, and it's not there. And also for some of the mentors, not to also sexually abuse or harass such mentees, especially where they are female, and then the seniors are male or something like that. But also know that you have to provide for them professional guidance for growth in the profession, to steer them away from situations that may get them in trouble. So if there need questions answered about ethical issues, it have been done this, what do I do? Is it right for me to do this? To provide a guide for them, to advise them when they have issues that trouble their soul and they're not quite sure how to move. So I think if we're able to look at some of these things, and then we do a bottom-up approach when the branches have done that, the National Secretariat of MBA may also is to provide institutional support to the branches, and all where necessary provide logistic support for them to be able to implement, but making it a policy trust of the MBA so that the branches can also key into it and implement it, with MBA, National Secretariat of MBA overseeing it and making it a top priority project, so that every young lawyer is not left out of the loop, that the MBA pays attention to them and also gets reports and conducts surveys and analyzes data emanating from it to see how well it is working, areas that need to be areas that need some jigging to ensure that the process is not abused, that also the mentors don't turn these mentees into their slaves for free labor. Oh, I'm mentoring you, do this for me, but I'm not paying you salary. You must do it for me. I'm your mentor. You've been assigned to me. You have no choice in the matter. finding that balance is also very important.
Thank you very much, sir. Then back to issue of sexual assault and microaggressions. Many female lawyers have encountered these issues in the place of work, outside the work, and it's kind of has made them draw back, or has really affected their strength, affected their positivity towards the work, and has made them sometimes leave the practice. So, what advice do you have for female lawyers in this regard? How to go about these issues? Because it's a burning issue, even though many people don't talk about it.
So the Me Too movement that started in the US has taught us that sexual harassment in workplaces is a life issue. And even
Yeah,
celebrities, big persons suffer it. And many people decide not to talk about it because oftentimes the victim is made to
yeah,
feel the sense of shame, as if that we
shame.
blamed for this. Um, I'm not quite sure, but I think NBA has a sexual harassment policy which was
Yeah,
launched or has been. But I think if there's one in place, which I can't quickly confirm at the moment,
yeah.
is
There's
for us
one in
to
place.
for
Yeah,
for I think there is, but if there isn't,
yeah,
one should be in place for every law firms to be made to implement them and sign them and make them part of the employment policy, and will
okay,
define what amounts to sexual harassment in the workplace to protect
okay,
young persons who come to work in places, because it destroys people. It can be traumatic. It can
yeah,
also lead to suicidal thoughts, or maybe actually,
yeah,
I don't know. But as a professional organization, NBA should also lead that war to ensure that sexual harassment in the workplace is eliminated. If we can't eliminate it, at least to bring it back to a minimum, and have some
level.
institutional support for persons who may be victims of sexual harassment to ensure that
Yeah,
they have some form of redress. And incidentally, our rules of professional conduct says nothing about it. And that
yeah.
should also be something that the rule should be amended to also define it
Reflect.
and reflect it, and also make specific provisions for it. Just to say that even though women are usually most of the victims of sexual harassment, they are by no means
Yeah,
alone. That is also their males are also harassed, and I say no more about this matter. But just to say that sexual
of course.
harassment is an issue that we should give serious attention to and tackle.
Yeah. Um, Now back to issue of RPC. So do you think the RPC should be amended to reflect the
Oh yes.
realities of our time and dispensation, especially with the rise in or the increase of technology, the use of technology?
No, whether we beyond technology, I think our RPC is not in sync with modern realities. They already made a suggestion about having sexual harassment thing written into it.
Yeah,
It's reflecting that.
yeah,
There are many in my days as a prosecutor in the LPDC, that's Legal Practitioner Disciplinary Committee, and in
committee.
my days as General Secretary, where it was my duty to review petitions and forward them to that place for trial. I
Yeah,
realized that so many allegations of professional misconduct could not be specifically accommodated under any particular rule.
mm,
So you used to, there's a particular rule, I think rule 1 and rule 15 or something, that were used usually for omnibus charge. Even though I
issue.
know that the species of professional conduct is never closed and you
Yeah,
can never fully determine it, but there are some things we would expect to see in the rules of professional conduct that
yeah,
ours lack. So I think the General Council of the Bar should initiate the process of having our rules revised. We look at other jurisdictions and see the kind of things they prohibit. But also a better starting point would be the Legal Practitioners Act, which only makes it a professional misconduct if the infamous conduct or misconduct being talked about is done by a lawyer in the discharge of his duties as a lawyer. So if I, as a lawyer, I go out and I beat up my wife, or I do
yeah,
something crazy, like maybe I strip down my clothes and run naked in the street, which brings
yeah,
embarrassment to the legal profession, there's no
yeah,
provision that allows me to be brought there because I can say I was not acting like a lawyer. But in other
yeah,
countries, if you're drunk driving, you do some things, the fact that you're a lawyer opens you up to a misconduct hearing.
yeah,
So Clinton was indicted, was impeached in the House of Reps for the affair with Monica Lewinsky. He was never tried or convicted, but for that fact that incident involved him, and he was impeached for that, the Arkansas bar, where he was called, suspended him. In Nigeria, it would be difficult to do that because he was not acting in a professional respect. So as is antiquated, both the law and the rules, they need to be revised to take care of these situations. But if my conduct is considered so infamous that it brings disrepute to my profession, to my colleagues, then I should be able to face professional misconduct. If I live in a man's house and refuse to pay him rent for 10 years, I devise all manner of legal tactics to keep him away from, and in justifiable circumstances, he should be able to open me up to professional misconduct hearing. But in Nigeria at the moment, we just can't.
This is our food for thought, and we hope the right thing be done soon. With respect to dispensation of our cases and decongestion of our courts, what advice can you provide to help the judiciary in terms of the congestion of the courts? The cases are so much. There's delay in justice delivery, so it's been kind of frustrating for some lawyers who are into litigation. So, what advice do you have for the judiciary?
So, it's a mixed bag. I start from the bench. Appoint right persons to the courts. The courts should be able to take firm control of their courts. I mean, appointment, you must get appointment right. Get people who are young, who are intelligent, who are smart. Don't allow considerations other than merits and professional competence in determining who gets to the bench. For practitioners, and then change of judicial attitude. In Nigeria, we keep saying that it is against public policy to allow a losing party to bear the legal cost of the winning party. But in many cases, people know that there's no reason to go to court. But they simply go to court to keep you in court so that you will not be able to do certain things, take certain actions. And some people will even boast to you, don't worry, we'll go to court, we'll stay there for 10 years. So they're simply keeping you in court. And even when it is so clear that such a person ought not to have taken you to court, the court still refused to award cost against the losing party who brought this useless action. The lawyer who also knows that the action is frivolous, but nonetheless brings it to court, walks away, nothing happens to him. So we refuse to impose cost on the litigant who has abused the judicial process just to annoy another person. We let off the lawyer who knows that this case has no business in court, but who goes to court. We let off people who can ordinarily settle a matter, but they choose to go to court. Appellate process. These are starting points, ma'am. So when we put a cost calculation measure in place so that when a losing person loses, he's able to recover his cost from that man who took him to court. He will think twice before going to court. If a lawyer knows that for taking up a case, for not claiming that he believed what his client told him, when it is clear that he ought not to believe the client, facing a misconduct issue, pay. These are, for me, these are low-hanging fruits that we can utilize. And some judges should give bench ruling. There are some situations require bench ruling.
Of course, not an adjournment.
They adjourn it. And certain applications that will go to court to waste time should be handled administratively. Why do I need to go to Supreme Court, for example, for an extension of time to file brief out of time and deem it filed when it's already there? And when the court routinely grants it, why do I need to go to court for extension of time to transmit record of appeal out of time, statement of defense? Why can't we, as is being done in places like Anambra, where the two counsel can what they call extension of time by consent, sign a paper and it is done, or have a deputy registrar do that as an administrative work? Since extending time, especially where it is not contested, is not much of a judicial issue. Parties they do that. It's a procedural issue. Why can't we find ways of doing this? Why can't we also look at our other courts adopting a provision of Order 38, I think, of the National Industrial Court Act, that allows parties who have filed defense to say, we agree by consent that to deem our processes as adopted, so that they file final address and the court will now give judgment.
Hmm.
There's a whole lot of things, and also to allow courts matters that they feel are not really serious to find a way of getting them sorted out. But here,
Hmm.
if a judge expresses opinion or tries to suggest parties to will settle, there is
Yeah.
no case. Somebody will say the judge has taken bribe. They will write
Right.
petition against the judge. They apply for transfer of the case, and then people come keep getting adjournment, and they get away with them. That's why I talk about judges taking control of their courts,
Yeah. Hmm.
and lawyers also knowing what they are doing. Sometimes there's this allegation that some lawyers keep matters in court because they are collecting what they call transport or
Appearance.
appearance fee. So they are much more interested in that than in closing the matter.
Yeah.
They raise all manner of objections that they are more interested, the story goes, in collecting those monies. So the longer they keep it there, the more money they make. So they
They
don't
make.
care about the pressure they pile on the system, the frustration it brings on their clients, and so on and so forth.
It's an issue. Yeah. It's a whole lot of issues. So just to wrap up this session, I want us to talk about the issue of health of lawyers, because if you're not healthy, you may not be able to enjoy your practice or do well. We've seen instances where lawyers slump in court, lawyers die young, issues here and there. As much as death is inevitable, but managing our health is something we can do. So, what advice do you have for lawyers who will watch this interview in terms of managing their health for effective practice?
Every lawyer must care about work life balance. It's only a healthy lawyer that is useful to a client. If you break down and you're a sole practitioner and you're taken off for a year, you may come back to discover that most of your clients are gone. Or if you die, your clients will go. But even if you have a partnership and you're still being useful, it will be good for you to be alive and healthy. So caring about our life, doing medical check, going to hospital, and also exercising, and knowing that no matter how much we try, our health is very important. Like Mahatma Gandhi said,
Yeah.
that in a bid to make money, we
Hmm.
destroy our health and we start
Yeah.
spending money to get our health back.
Back.
Lawyers, like many other professionals, are good examples of that. So we should try as much as possible to find a balance between the work we do for our clients and work and how we take care of our health. So we must make sure that we do not neglect our health. We also
Yeah.
take out insurance, health insurance, in
Yes.
case of emergency, and have
Yeah.
known hospitals that have a medical history. And in case of any medical situation, you may have an idea where to take you if you're within that locality. But
Yeah.
prioritize your health, because you need to be a healthy lawyer to be able to render services to clients in whatever is fair that you see yourself.
Yeah, thank you so much, sir. It's been a wonderful time. And from us here as a team, we are very grateful for your time. We do not take it for granted. Thank you for everything. Thank you for sparing these few minutes to talk to us. And we do hope that these solutions you have provided will help one of any lawyer or anyone who will come across this chat to reevaluate their lives and practice, to understand the dynamics of law practice and see ways to help them grow. We so much appreciate you, sir. Thank you very much.
Thank you so very much, and thanks for
Yeah,
having me. Have a blessed week.
thank you. And you too,
All
sir.
right,
Thank you.
all right, ma'am.
Yeah.
Okay, bye bye.